Shalom, this is your Ark. Yah is magnified, coming back with another informative video. I titled this video, My Motion Was Denied, Now What? But before I tackle this subject, as always, I must state for the record, I'm not a lawyer, I do not practice law, and I do not pretend to. All my videos are for informational and educational purposes only. They're all facts and all truth. Nothing more, nothing less. So with that being said, let's get to it. Okay, so now as you all know, I tell you all this is the year of testimonies, and I'm going to put up a lot of testimonies, okay? But this video right here is about the opposite side, okay? The testimonies is the positive side. This video right here is the negative side when fighting for freedom from this child support situation, okay? So my op, he sent me this in the mail. He received this in the mail after we filed a motion to vacate the hearing officer's recommendations, okay? So my aunt been working with me from the beginning, okay? Before he was even placed on child support, he went to court with me from the beginning, okay? So because he went to court with me from the beginning, I know his whole situation from the beginning to the end, so far to where we at right now, okay? So in his situation, we went to court, we filed our documentation into the court, he stood on the square, boom. The support magistrate says, okay, she's going to let him know, what the outcome going to be in the mail. She's not going to answer right now, but she's going to send it to him in the mail. Okay, so all parties left. My aunt was like, yeah, he did good. I know he did good. He was like, the agency didn't look so happy, and the child's mom didn't look so happy when he left. So he get home, and then he received the recommendation from the hearing officer, and they come to find out that she somehow still has him paying support. So he like, hold on, brother. How did this happen like this? I said, man, I don't know. And then right after that, we received in the mail, he received in the mail, should I say, a order from the support magistrate approving the hearing officer's recommendation stating that he has to owe support with arrears. We like, hold up. They haven't provided any type of evidence on it for the record to prove anything, but they are still claiming that he owed support. So when he received that order from the support magistrate, ordering the hearing officer's recommendations to stand as an order, so we immediately moved to vacate that order. Why? Because the order was void. It's a void order made out of complete fraud. No case law, anything to back it up, just a complete fraudulent order. Okay, they have nothing to support their claim that he has to pay support. When I say absolutely nothing, guys, I mean absolutely nothing. So my aunt went back into the court on the motion to vacate, shut it down, man. He sent me the recording, shut it down, did a good job, man. The agency didn't have a rebuttal. They could not rebut anything that he stated. And because they couldn't rebut anything he stated, again, the support magistrate said, this time when he went before the support magistrate said he went before the same, matter of fact, let me go back, because he went before the same support magistrate that signed off on the order of the hearing officer, okay? Which is collusion right there, but we're going to keep it moving, okay? So we knew the cards were going to be stacked against him, but he still went in there and shut it down, and he showed the support magistrate that, hey, I know what I'm talking about, I know what's going on, hey, this is what we're going to do, this how I'm handling it, and that's going to be that. So he went in there and did all that, 2 to 3 weeks later, we received this. So I asked my aunt, can I, share this all with you all? Even though it's not a positive thing, he was railroaded. But he said, yeah, cool, share, just blank out my information. I said, okay, like always, I always blank out the information. When my aunt was like, when he hit me up with this information, I can feel the pain in the text message, man, the message that he sent me when he sent me this, he was like, brother, they ruled against me again. I don't know how, I'm starting to lose faith and stuff like that, but I told him, I sat down like, hold on, brother, ain't no such thing as losing faith. You know what I mean? Like, look, I fought for 4 years, brother. This is only your second time going back into this court. He'll vouch for me. He'll tell you I said the same thing. I said, I told him, like, it's been 4 years before I got the remedy and I won my situation. So I said, brother, you only went to court twice within a few months. I'm like, this thing is a fight. I tell everybody it's a fight. I said, your faith can't dwindle, brother. He's like, you know what? You're right. I was like, man, we got to move to the next step. He was like, what's the next step? I said, that's a good question. Because a lot of brothers don't know what's the next step after they go into these courts and get railroaded. Okay? So what they do is come over to me after some months have passed and say, yeah, I went with so and so, filed some documentation into the court, man, didn't work for me. Now what? So for the brothers that's saying now what, your next now what is the appeal, okay? You go through the appeal process. This is what no one is basically talking about because a lot of people don't know how to uh, do the notice of appeals, write up the appeal briefs and stuff like that. They don't know how to do assignments and appendix. If you have to file an appendix into the court with your appeal brief, a lot of brothers don't know these things. They just know what they read and then they tell you all to go in there and try it like some type of guinea pig. You go in there and try it. Then when it don't work for you, they don't have a backup plan. Okay, but they say do this, do that, file this, file that. Okay, so yes, even though my ARC motion is denied, this is a learning lesson we all can appreciate because we're going to read exactly why they denied it and did the court even have any factual evidence on it for the record to deny it, and did the court put any case law up or any statutes or codes to support the support magistrate's ruling and denying the motion. Okay, that's how you know if they had the right to do what they said they had the right to do. So let's pick this up at the top. Okay, it states in the circuit court, 4th Judicial Circuit in and for Duval County, Florida. As you all know, I got testimonies in the state of Florida, brothers going in there winning as well. Okay, so like I told you, not only am I going to show y'all the positive side, I have to show you the negative side as well, so you all can know that, hey, it's not always sunshine and rainbows, but you must continue to fight. Because with this negative side right here, it will become positive after we finish the appeals court. I can pretty surely guarantee it to be. Okay, but I'm putting it out there right now that my art, he just received this 2 weeks ago, 2 to 3 weeks ago. No, he went there 2 or 3 weeks ago. He just received this 2 or 3 days ago. He sent it to me, and we haven't even started the second process yet. But when we start it, and we're going to go through the whole thing, he will be on here to give his testimony that he won. I'm speaking it into existence right now, because I know these things, and I know what we did. I know the work that we put in, because I've been working with him from the beginning. And I'm standing behind what I do. So be looking out for his testimony in a few months. Who knows how long they're going to take to get back with him on the appeals, because I have brothers that's in the appeal court right now that it's been 7-8 months and they still haven't received a response yet from the appeals court. So who knows how long they're going to take, but we're starting on it and we're going to be working on it starting probably next week. But let's continue. It states, as you all can see, this was in Florida. But let's continue. I crossed out the case number, as always. I crossed out his child's mom name, as always, and the state of Florida Department of Revenue. I kept that the same. But it's crazy how the state of Florida Department of Revenue can even be a plaintiff. But hey, we don't know any better. They perceive as though, they have the right to do what they're doing. This is ridiculous. But let's continue. It says versus Ma'ak, who is the defendant. Okay. Let's read the order. It says, order denying defendant's motion to vacate. So let's read it. This cause came before the court for a hearing on April the blank 2019 on the defendant's motion to vacate final judgment of blank of the enforcement hearing officer, like I told y'all. So the enforcement hearing officer put in a recommendation that the support magistrate, who also denied this motion right here, signed off on to make it an order. Okay, so this is two different situations that we all combine it into one. Okay, because like I told y'all, it's levels. You got to keep going up to the next level, to the next level, to the next level till you get what you want. But let's continue. It says, so let's go over it again. On April blank 2019, on the defendant's motion to vacate final judgment of blank of the enforcement hearing officer and income deduction order, child support, and arrears payments, which is attached to the notice of hearing, docket number 24, Kevin Blank, Esquire, attended the hearing on behalf of the plaintiff. The defendant appeared pro se. Okay, so he went in there on his own. He didn't have an attorney or anything to support him. Just information and documentation that I gave him, and he stood on it. He did a wonderful job, even though they denied him. But let's continue. It says the court. Now, this is what the court did to deny his motion. Now, let's continue. It says the court, having heard the testimonies of the parties, having observed their demeanor and evaluated their credibility, having relied upon the observation and evaluations in determining the facts of this case, having received evidence from the parties and heard argument from the counsel for the plaintiff and the defendant pro se, it is therefore ordered. So again, what did he base his order on? He based his order on, again, let's read it again. Okay, after hearing the testimonies of the parties, now this is what he bases his ruling on the motion for. Having observed their demeanor and evaluated their credibility, right? And relied upon those observations and evaluations in determining the facts of this case. So he basically only made his determination on the demeanor and the credibility of what they were saying. He didn't base it off the laws, statutes, and codes that was placed in evidence before his face. So with that being said, when we go into the appeals court with these same arguments, with these same assignments of error in the appeals court, and the judges cannot answer these arguments, which they made an error in, then cool, the case will be turned over again. Okay, because law is not judged off actions and demeanors. No, it's based off of statutes and codes and laws. He didn't mention that in making his ruling. That's why I told my Ak. I said, Ak, go back and read this one more time, and then you'll see why I said you must continue to fight. Because if you don't fight, then you're going to automatically let this void order, which is a clearly void judgment against you, stand. You see what I mean? That's because the simple fact of the matter is, this order has nothing to do based off the law. It only was determined off the demeanors and the credibility of what was said in the court. So just because he didn't like the way my Ak said it and the way he said it, doesn't mean that what he said wasn't based off of law, facts, and truth. But let's go to the second page where we can see what was ordered in the judge. So let's go. It says, number 1, the defendant motion to vacate final judgment of blank of the enforcement hearing officer and income deduction order of child support and arrears payments is denied. He never said why he denied it. He never gave law, statutes, or codes to support his evidence in denying it. So when we get into the appeal court, we're going to have a field day because they're not going to be able to answer it like he can't answer the questions that we ask. You see? So just because you are denied doesn't mean that they had the right to deny you. Okay? So this is more facts, more truth, more proof. Just be ready to go through the fight. I tell everybody, this is not an easy fight because you're dealing with crooks. But it's a fight worth fighting when you win. That's how we get remedy. You must know what's next. Okay? You have people who's helping or assisting you with your situation. They tell you to file this, file that because they read this and they read that without having true understanding of things that they're reading. So they have you filing federal documentation in the state court, which is completely bogus. You see? But they still have you going to do these things, and then you ask them yourself, did you all do this before? Do you have evidence? Do you have testimonies? Do you have facts that they actually work? Did they work in your case? Did you file this in your case? Did you get remedy? And they say no. Or they say, well, I haven't done it before, but I believe it worked. Man, stop becoming these guys guinea pigs. You must continue to be with someone who's been through it already. I have experience in trial courts. I have experience in appeal courts. Okay? I have experience in the Supreme Court. Okay? I have the experience. I stay out of federal court. Okay? We're talking all state here. I stay out of federal court. State here. Okay? But again, as we all can see, his motion was denied off the emotions of the judge, whose name was William Collins Cooper, the circuit judge. He based his ruling off emotions alone, not off the law and the factual evidence that was placed on it for the record before the court. So, my Ak, we will be back in there fighting to get this thing settled and situated. Okay, so he will be one of the testimonies coming up in the future, because right now the appeal process takes some time. He has 30 days from the date that he received this motion to start his appeal. Okay, so We're starting the next week, and we'll be moving forward. Okay, so for the brothers who dealing with the appeals, you must understand what comes with that. The appeals is a harder step than dealing in the lower courts, okay? Because you need to file. I'm going to give you the first step in filing your appeal for the brothers that's going through it. You must first file your notice of appeal. Then after that, the appeal court will send you documentation stating what you must file in the appeals court, which would most likely be even an appendix. You know, some court cases or some appeal courts say you must file an appendix or something in the form of an appendix and an appeal brief together. Okay, you must know the color of the appeal brief that the cover page must be, because some states, you know, the appendix got to be blue. Some states, if they have you file the appendix, some states you don't have to file the appendix, you know, or some states say, okay, well, your cover letter on your appeal brief must be red. So you got, and they tell you how you got to bind it. Some of them got to be tape bind and stuff like that. Some got to be spiral bind. It all depends on the state. You have to know your state rules and codes when filing your documentation, when filing an appeal. Okay, but not only that, you have to know your assignments of error, you know, your table of contents, your table of authorities, and everything else that comes with filing an appeal. Okay, your summary argument, your argument, everything, you know. When doing an appeal, it's like doing a book report. It's not just going in there, filing a motion, and then boom, it's over with. No, it's steps to doing an appeal, okay? And you must articulate yourself in your appeal, you know, because when you have to go before these appeal judges, then you will be able to stand and state the reasons of why you believe what you believe, and then the appeal judge have to prove otherwise different. And if they cannot prove different or disprove you with the law, then the case will be dismissed. And as I just proved with this motion to vacate, this judge based his whole ruling off emotions alone. That's it. That's all. So before I go, let's go back over again on the reasons why he denied my ox claim. And let's see the words statute, codes, or laws in it at all. Let's go there one more time before we leave. Again, the court, having heard the testimonies of the parties, having observed their demeanor and evaluated their credibility, having relied upon the observation and evaluation in determining the facts of this case, having received evidence from the party and heard argument of counsel for the plaintiff and the defendant pro se, it is therefore ordered, and they denied it. They didn't base it off the statute, rules, and codes of the state, you know, to support their evidence of denying it. No, simply demeanors and credibility. So you don't have to take nobody's word for it if the law states what it states. Okay, if you can provide proof of evidence of what it states. So with that being said, that's all I'm going to do for today. You know, everybody enjoy your weekend. It's time, I got to spend time with my family and everything like that. But if you all need my help, you know, hit me up at my email at yahismagnified@gmail.com. If I don't